welcome to Insta Vision. I'm here in the stately basement courtroom at stately Instapundit Manor, and I'm joined by Benjamin H. Barton. He's a law professor and director of clinical programs at the University of Tennessee, and he's also the author of a very important new book from Cambridge University Press called The Lawyer-Judge Bias in the American Legal System. Welcome. Thanks for joining us.
My pleasure. Thrilled to be here.
So your thesis, I think in some ways this doesn't strike people as odd or shocking, but for legal scholarship it's unusual. Your thesis is basically that judges tend to side instinctively with lawyers and the legal profession, and they tend to rule in ways that make the law more complex and benefit lawyers. Is that right?
Yes, and actually it's sort of funny. When you speak to regular people who are not lawyers or judges, they find this patently obvious. And they're pleased that I have a bunch of examples of it and that I've taken the time to gather them, but it's not surprising to them that this would occur. When you speak to lawyers, some law professors and judges, however, it's, whoa, hey, you must have misunderstood something. Like, maybe you didn't get the memo that this isn't how things work.
Yeah. Well, you know, it is funny, is it? Because it really seems like that's what most people think about lawyers, and yet, why is it that to lay people this is obvious, but to lawyers it's kind of a blind spot?
Well, one thing that's actually sort of funny about it is that most lay people do not have a favorable impression of lawyers, but their impression of judges in the judiciary is much, much better than that. All of the polls, judges poll 20, 30 points in terms of favorability ahead of lawyers, which is a little bit odd, right? Because virtually all judges are former lawyers. You would think there would be some bleed over between those two. And then there's sort of this, and some of this is good, but I mean, there's a built-in bias just among people in general that judges are not self-interested, that judges are choosing each case and applying the law to it very simply, and that these sorts of biases don't happen. So that's one of the reasons why I think it's sort of important to gather all of the different case area where it has happened and then make the argument.
And you've really looked at this from the standpoint of sort of public choice economics and the new institutionalism. What does that mean?
Okay, so both public choice and the new institutionalism are economic theories of non-economic behavior. So public choice theory starts from the point of view that every person, even non-economic actors like bureaucrats or elected officials or judges, are self-interested and rational. And they seek to maximize their own utility, which means basically to make their job and their lives as good as possible. So again, that doesn't seem like that's very controversial, but when you apply it to judges, so for the federal judiciary, they're appointed for life, their salary can't be cut or changed, their salary doesn't go up or down depending on what they rule in any one case. A lot of people sort of assume that they will be quite impartial when they come to these cases. But you see, when there are these cases where the legal profession as a whole comes up before them, that they naturally empathize, sympathize, and work with the position of the legal profession.
And you actually have a lot of examples of that in the book. In fact, that's most of the book. One of the things I like was the notion that state-supported lawyers have a lot more freedom of speech than, say, state-supported doctors. I mean, how does that work out?
Right, so it's sort of funny. Congress pays money to these various people to do things, and then sometimes they do things that annoy Congress, and so Congress tries to put limits on it. So in the 80s, they put limits on doctors in giving any advice that could lead to abortions. And so the doctors appealed on their First Amendment basis and said, look, we're not saying that we should be paid by Congress to just say nothing but abortion, 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 but we're doctors. We have to be able to give you the full range of the medical procedures. If we're not going to be able to fulfill what we consider this sort of sacred doctor-patient relationship.
Right.
And so the Supreme Court said, oh, poo-poo, doctor-patient relationship. This is just Congress picking and choosing what they're going to pay for. And they basically gave very short shrift to the doctors. And it was one of these things where the AMA and every other group of doctors came together to say, this is a serious problem for us. We have to be able to give our full and unbiased advice. So fast forward, Congress gets annoyed with legal aid lawyers who are government-paid lawyers. And they put a limit on what legal aid lawyers can do. Legal aid lawyers are allowed to represent individual clients, but they're not allowed to argue for the unconstitutionality of any government act. And so this comes up, and the government says, well, I don't know if you remember what happened with doctors. This is the exact same case. This is just the government picking and choosing what it is that they want to support. and you get just a completely different result when it's lawyers now. And it's actually Kennedy who writes the Velasco, which is the lawyer decision, and he joined the Rush decision against the doctors. And for the lawyers, he says, well, there's this attorney-client relationship, and how can you possibly not give the full range of advice? And
exactly what the doctors were saying.
Exactly.
Yeah, exactly.
I mean, same exact argument. And yet now it's got a whole bunch of credence because it's lawyers.
Oh,
and
yeah,
it's
lawyers,
really
sure.
interesting. In particular, there's a level of pique and irritation with this law where Kennedy says, well, I mean, how can we expect judges to have to only get part of the arguments that they're entitled to? And so that case is just a perfect example where one profession gets treatment A and the legal profession gets treatment B.
And then the same thing's true with attorney-client privilege versus doctor-patient privilege, right? The doctors get the shaft again.
Right. Oh, no, absolutely. I mean, the attorney-client privilege has been around. It's the oldest privilege. It's been around for 400 to 500 years, depending on how you count it. It's always been created through the courts, not through the legislature. And going all the way back to England, the first time it comes up, the justification for the attorney-client privilege is, well, we need clients that would talk frankly and clearly with their lawyer. If the lawyer was going to be able to testify in court about what they said, they wouldn't give full advice on it, which, as you can imagine, is the exact same argument for the doctors, right? And I would think that if you weren't a lawyer or a judge, it's actually more important that you're consistent and tell the truth to your doctor, right? You don't want to be hiding things from your doctor health-wise. But when it's applied to the medical profession, they actually say the opposite. They say, well, who's going to lie to their doctor? That's ridiculous. So yeah, so the attorney-client privilege is treated much better. It's court-created. All of or in the United States, the doctor-patient privileges are created generally by legislatures and have more exceptions to them.
And then yet another place where lawyers do better than doctors, and actually every other profession, is malpractice, right? It's much harder to recover against your lawyer for malpractice than your doctor, even though there is some legal malpractice out there.
Yes, no, absolutely. And this is just a perfect place where you can see how it works for the judges, right? So when judges hear about medical malpractice, the doctor's lawyer comes in and says, you know, we're tying the doctor's hands, there's so much litigation, they're going to be second-guessing every decision they make. But the judges haven't been doctors, but they have been patients, right? So when the plaintiff's lawyer comes in and says, well, Your Honor, I mean, look at this horrible malpractice, the judges naturally sort of gravitate towards that argument. The opposite happens in legal malpractice, right? You have the defendant come in and say, oh, Your Honor, I mean, think about the devastating effect on the legal profession if we allow this sort of these problems to happen, and the judges naturally, they understand that, and they make it much narrower. It's much harder for third parties to sue lawyers. A lot of the innovations that have come in for medical malpractice haven't followed for legal malpractice.
So yeah, and that's true with consumer protection type stuff generally, right? Lawyers kind of get a pass on a lot of things that other professions suffer from for sort of the same reason. You've got a lot of examples of that as well.
Yes, yes. No, a lot of state consumer protection statutes, lawyers have been carved out of them, even though they're facially neutral. They just say anybody who's in business or something of that nature.
And then the courts say, except lawyers.
Well, no, they don't say that. They do. They say a bunch of different things, but my favorite thing that they say is, well, law isn't a business. How could we think? How could we be confused to think that these lawyers are in business? Yeah.
We're more like saints, really.
Right, exactly.
Well, and my favorite example, actually, the whole thing, was what happened to all the people in the Enron affair, right? Because the accountants get in trouble. I mean, they go out of business, some go to jail. Of course, the people at Enron do. But who basically skates away with almost no penalties? The lawyers, right? How does that happen?
Right. Well, this was one of the ways I tried to tie up the end of the book, is I wanted to sort of show where the rubber hits the road. And the Enron thing is just a perfect example of that. I mean, Arthur Andersen is this ongoing concern that employs thousands of people all over the world and has existed for almost 100 years at the time that Enron happened, and it's just demolished overnight. And obviously Enron is completely destroyed. A bunch of people at Arthur Andersen and at Enron end up serving prison or facing criminal charges. And yet the two main law firms that worked for Enron and the in-house people and the lawyer at Arthur Andersen, all of whom were very complicit in all of the various things that went on, all of them basically skated. I mean, the law firms paid a small, or depending how you look at it, they paid less a lot less than they earned from Enron back in a penalty, which to me is small.
Yeah, yeah.
And none of them got disbarred. None of them spent any time in jail. Not basically, they paid a fine and moved on.
So what do we do about all this? I mean, I guess one thing you do is you just talk about it, right, and sensitize judges and people, because apparently while lay people know this, the legal profession doesn't. Beyond that, what do you do? I mean, do we get non-lawyer judges? Like we've had that in the United States, you know it, and they have that in Germany in some cases. What else? Do we specially train judges so they think of themselves as something other than lawyers, or what do you think we should do?
Yeah, so I have a sort of a solutions thing at the end of the book. The best thing, I think, is just sort of sunshine is a good disinfectant. I'm drawing attention to this. I'm trying to make people see it, and hopefully that will affect the judiciary and how they act. But aside from that, yeah, all of those things are super interesting. I mean, there's a blind spot here. I mean, people feel as if it's preordained and it's always been that all of the judges are former lawyers and how could you do anything else? But that's, in fact, that's not historically accurate. There's no requirement that the members of the Supreme Court have to be lawyers. Even right now, they can appoint.
I think under the Reagan administration, they actually looked a little bit at appointing Thomas Sowell and did some research on that, but they decided politically it just wouldn't fly.
Right, right. But yeah, and that would certainly help, and especially we were talking about the complexity issue. Complexity is a huge benefit to lawyers, right? The more complex the system is, the more likely it is that you're going to hire a lawyer. And not only that, you really need a good lawyer because it's so complicated that you could get a bad lawyer and they could really screw it up. Presumably, if you had non-lawyers, the argument against non-lawyers is it's so complicated, but that's sort of a humorous backwards argument, right? I mean, you could hire non-lawyers and maybe the first thing that they would do is try and make it a lot easier and more straightforward and simple. Of course, that may explain why it's not going to happen, because you're not going to see lawyers or judges giving up that power anytime soon.
And on that hopeful note, I guess we come to an end. The book is called The Lawyer-Judge Bias of the American Legal System. It's by Ben Barton, who is a legal genius par excellence. I hope readers and viewers will check it out.
Well, Glenn, thank you so much for having me on. I really appreciate it.
Thanks for coming on. It's great. Thank you. And thanks for tuning in to InstaVision. We'll be back next week with more. In the meantime, have fun on the internet.